Welcome back to r/LegalAdvice, where we read surprisingly interesting stories that usually don't end in a cliffhanger. If you are new to my channel, please feel free to subscribe to join our awesome community, and without any further ado, let's dive right in. And the first one is titled, "Over 30k has been transferred out of my wife's 401k and HR won't tell us where it is and when we will get it back, in Arizona." Hello again, Legal Advice. My SO's 401k account was pilfered in its entirety in early September. All of a sudden, the 30+ k she had in there was transferred out. Her former HR representative told her to hold tight and wait for news. It is Friday, we called on Sunday, and the HR department is being coy and giving us the runaround again. Apparently, the account was owned by First Utah Bank, which has been recently hit with a suit because the owner has been stealing millions of dollars out of retirement accounts. 5 withdrawals called exit transfers were processed in September, all on the same date for various amounts, the largest being about 28k to 2 separate institutions named as American Century One Choice and Eaton Vance Worldwide Health. At this point, we have no idea what the hell we are supposed to do. Who the hell are these people? What the F is going on? Where's our money? The question is, should we lawyer up? We know of an employment lawyer, but she's not cheap. Our budget is really tight. If we lawyer up, is there any chance that the bank or her old company would be on the hook for the bill? I don't want to sink hundreds of dollars we don't really have into a lawyer if we are going to get the money back anyway, but it is totally worth it if it's the only way to get some frickin' answers about where 30+k just disappeared to. Any help or advice is appreciated, thanks. And a user in the comments said, "If this happened to me, I would get a lawyer as soon as possible and call the local FBI field office about it." And guys, I'm curious, what would you do in this situation? Would you also straight away contact the FBI, which by the way seems kind of weird to me? Let me know in the comments. And someone else in the comments said, "American Century and Eaton Vance are both investment management firms. My guess is that the company is changing 401k providers, probably due to the issues you mentioned, and the funds are being relocated accordingly. Before lawyering up, I would suggest giving the company another week. Keep reaching out to HR. Also, it might be worth talking to other employees she's in touch with to see if there are any other changes happening to the 401k program." And then another person answered, "Employers are mandated to provide employees and non-employee plan participants with a notice of transfer and blackout notice. There are substantial fines for failing to do so." And by the way guys, on a side note, I know usually I don't read that many comments, but in this case I found them particularly interesting and helpful. Then again, please let me know in the comments if you don't want to hear that many comments. And now the update to the 30k which has been transferred story. Hey Legal Advice, thank you for your advice on the issue of my wife's 401k. We called quite a lot of people, threatened to bust heads, not really, but we did stress that it is thirsty effing $1,000 we are talking about, so don't give us the runaround. And received a bit more info about what is going on. If any of this sounds sketchy, let me know so we can follow up. I would super appreciate it. So we called one of the companies the balance was transferred out to, named Equity Trust. They said that the blackout period was going to be September to November, which was shortened to September-October, but is now back to November because of the size of the account that her old company had. They are apparently still in the process of reconciling transfers, balances and all that crap between about 6 different directly and indirectly involved companies. The bottom line, they told us, is that we will get the most current status of the situation and the exact balance the first week of November and probably not sooner. Well, one piece of good news is that her funds were never converted into alternative investments, which means real estate or trust funds. They are all still mutual funds. So the person at Equity Trust said that her funds should not be affected by the continuing criminal investigation into the guy who owned the firm, who previously mismanaged and stole money from retirement accounts. But because the funds were never converted, they said that we would not have received an official notice of asset loss like a lot of you said we were required to receive when the funds first went into receivership months ago. They went on about a bunch of financial bullcrap that went totally over my head. I cannot even decipher half my notes about why we were not required to be sent notification. I did not buy it, but what else are we going to do, you know? We did communicate that legal or not, we found it extremely poor customer service to suddenly transfer $30,000 without any notification or explanation and would be strongly reconsidering our relationship with that institution when the matter is cleared up. They ended the call by asking us to send screenshots of the most recent account transaction from the old firm so that they could compare the numbers once they and us have online access to the new account with the new managing entity. The person we talked to had us take down her direct line so that we could call her back if we had more questions. My wife and I have decided that that is satisfactory enough for us. And guys, obviously, at least for me, that was not the most satisfactory ending ever, but sometimes we just have to take what we can get. In addition, if you have watched until here, please don't forget to post some star emojis in the comments and also like the video if you want to support me. Thank you very much in advance. And the next one is titled, Looking at Gross Misconduct Dismissal from Work. I am in England, so I have a criminal record. I have been working here for about a year, and when I applied I did not disclose this as it is classed as a spent conviction and so it does not need to be disclosed. However, the conviction has since come to light. It is for something quite serious and will probably end up with me being dismissed as gross misconduct. Would I be able to go into the meeting, hand in my notice and ask for an immediate resignation so that it is not on my file as gross misconduct for references in the future? And a user in the comments said, I'm not a lawyer and I will be genuinely curious as to what the actual lawyers who know employment law have to say. That being said, I have multiple convictions, some spent, some unspent, and it is my understanding that if a conviction is spent for the purposes of the Rehabilitation of Offenders Act, and none of the various exceptions apply, then you are not obliged to disclose any convictions to an employer even if they specifically ask about prior convictions. My suspicion and thinking would be that if an employer subsequently discovers you have previous discussions that you did not disclose because they were spent, then that employer cannot take action against you for not disclosing the convictions. My feeling is that taking action against you by firing you for not disclosing a conviction when you were not legally required to do so would constitute unfair or wrongful dismissal. Whether you would have an actionable case or not is another matter. And then another person agreed and said, I would agree, I'm also not a lawyer, but it looks like the Rehabilitation of Offenders Act 1974 prohibits any employer using knowledge of a spent conviction as grounds for excluding prospective employees from employment or dismissing current employees unless an exception applies. I'm pretty certain a fast food restaurant is not an exempt employer. And the next one is an update to the conviction story. First of all, a huge thank you to everyone who took the time to respond to my other thread. You helped me going into the meeting today to be a little more prepared and to put my mind at ease. So I had the investigation meeting today. They seem satisfied that I did not lie on my application form, but they want some kind of evidence that my sentence was completed as I said, which is understandable if slightly annoying. I have applied for a basic DBS certificate, which should hopefully put this to bed. They have, however, now found out about the nature of my offense and they are looking at terminating me again under gross misconduct, with the reasoning being conviction of an offense deemed by the company to be serious. Can they do this if the conviction is from a good 10 years before I started and is now spent? As I said in my other post, I've only been here a year. Do I actually have any real options if they do fire me? I will be speaking to ACAS, NACRO, Unlock and a local solicitor at the earliest opportunity. I have spoken to ACAS, not really able to help due to it relating to a specific law. He said I did the right thing applying for my DBS basic certificate, but that ACAS can only speak about contractual issues. I have also spoken to NACRO, much more positive phone call. He said that what they are trying to do is explicitly illegal and they would be leaving themselves open to claims under both the Rehabilitation of Offenders Act and under GDPR/DPA, as they have no rights to hold that information about me. So that could be useful to know. Also, I have spoken to a solicitor, less positive. He said that because I had not been there 2 years, there would likely not be a lot I can do if they did fire me. Nothing more I can do now until 2nd January when places reopen after Christmas. And guys, I'm curious about your opinion. If you were a business owner, would you hire someone with a former conviction? Let us know in the comments. And the next one is the last update to the gross misconduct dismissal. They are dropping everything. My boss phoned me this morning and let me know that HR have said that as the conviction is spent, the original charge is null and void, and because of that, the second charge is not actionable. It is over. I go back to work as normal on Saturday following a period of sickness. Thank you so much to everyone who took the time to help me. You have no idea how much seeing all of your posts has helped me to keep things together over the last few days. It is amazing how much things can take a change in such a short space of time. Merry Christmas to all of you! Next one is titled, My school is not allowing access to toilets as punishment. The boys at my school, around 500 of us, currently only have access to 4 cubicles which are only open on lunch break. All other toilets have been locked from the inside to prevent use. They have done this as punishment for a small number of boys who have urinated all over the floor. This affects all boys on the premises. Some boys have had to use disabled toilets in order to not soil themselves, which, if caught, they will then be punished for doing so. Is this allowed to happen, and can I do anything about it? I understand the school will likely have much more power than me on my own. And a user in the comments said, the local education authority, at the very least, should be informed, and I would argue the local press, and if the local press are anything like my area, they love a good story about schools. Often rather frustratingly, regardless of if there is merit to the story, but there is merit to this one in my opinion. A few things that immediately jump out to me: number of available toilets. You state that there's only 4 toilets available. Regardless of the opening times, this is clearly not right. I'm not entirely sure if the HSE requirements for the workplace are applicable here, but there does appear to be a standard. 1 toilet or urinal per 20 students, of which at least a third need to be toilets. For example, for 500 pupils there need to be at least 25 and at least 7 actual toilets. Furthermore, the school's premises regulations of 2012 from the Department for Education. You state that the school is threatening to punish students who use disabled toilets. The Department of Education sets out guidelines for the premises of a school, and Regulation 4 explicitly states that all pupils should be allowed access to disabled toilets. Furthermore, there is the Equality Act. You state that it is the male pupils at the school who are being denied access to the toilets. I would expect this also falls under the Equality Act of 2010, as access to specific facilities, for example toilets, are being denied upon the basis of a protected characteristic, sex and gender, citizens' advice. This is also working on the assumption that the school is still providing reasonable adjustments to pupils that may require the toilet for medical reasons. If those pupils were also subjected to this punishment, then it would be very serious indeed. And guys, is it just me, or is this school extremely weird, considering that they are apparently punishing students for soiling themselves? Sounds more like a school from maybe 400 years ago than a modern one in 2020. And the next one is an update to the school story. A couple weeks back, my school locked all boys' toilets to target a problem where kids were urinating on the floor. Only 4 cubicles were available at any one time to over 500 boys. I took your advice, told my parents, and they took it up with the school. At first, the school defended the practice until my parents, and apparently others too, threatened further action. Thank you everyone, the toilets are now reopened. And the last one was posted by user Cruel1969 on our own subreddit and is titled "Mom embarrasses Dutch banker, 4 years later he springs his trap." This post has nothing to do with r/LegalAdvice, it is in fact a pro-revenge story, and please just consider this as a little bonus. I posted this on pro-revenge but thought maybe Ripe might like it as well. Ripe has my permission to read this story on his YouTube channel. In the early 80s, my mother had traced her ancestry to a small town in the Netherlands. She wrote to a woman in that town in the hope of getting help with research, and this woman and my mother ended up becoming friends. Not long after this, she and her husband were making a business trip near to where she lived, in San Francisco, California, and they arranged for a visit. It is important to understand what sort of person her husband was. Imagine the stereotypical Dutch banker. Very serious, very straight, at least publicly. Once we got to know him, he dropped the sham and turned into quite a likable person. But that was later. My mother asked where they would be coming into the country. It was in Texas. "Oh, do you speak the language? Don't they speak English? Oh no, they speak Texan." Now the Dutch banker was worried. His wife tried to assure him that my mother was just joking, they certainly spoke English in Texas. He said he did not think my mother was joking as they did not really know each other, but just before arrival in Texas, his wife had him convinced they would indeed speak English. By the way guys, one thing just to quickly interrupt that I'm curious about. Which state in the United States has the deepest accent that might be hard to understand for foreigners? Or rather, non-native speakers? Let me know in the comments. They walked up to the customs officer who greeted them with big "Howdy all." Horrified, he asked the guy very slowly, "Do you speak English?" Fast forward 4 years, 1986, and our family travels to visit their family. Their kids were just a bit younger than my sister and I. One day the Dutch banker and my mother both had business at the bank. My mother had gotten some real Dutch wooden shoes. They still use them there, at least then they did, which she wore to walk to the bank. When they got to the bank, several pairs of wooden shoes were lined up. My mother started taking hers off, but the banker said that was not needed. "They are the shoes of farmers. See, they are all muddy." So Mom kept the shoes on, walking into the bank. The bank had marble floors and a vaulted ceiling, perfect for amplifying the sound of wooden shoes walking on the floor. It did not take Mom long to notice all activity had stopped as everyone stared at this creation who had the gall to walk into a bank with wooden shoes on. The banker was smiling at her and said, "That was for Texas." Rest in peace, Mom. We miss you. You filled our lives with laughter. Thank you for the beautiful story, and indeed, rest in peace. And with that, we have reached the end of the video. I hope you enjoyed today's content, and if you did, please don't forget to subscribe to the channel to join our amazing community. Furthermore, don't forget to go to r/Ripe Stories on Reddit to post your own stories if you want me to read them out in a video. I hope you have a fantastic day, and I see you again tomorrow.